All right. Good morning. Good morning. Good morning. It's Friday, November 25th, and we are here for an exciting presentation with Greg Weedon, who will be joining us in a matter of minutes. Just hold tight on that. But in the meantime, I am, with your permission, going to do my normal introductory spiel before we begin, because usually our presenters start at 10:05, which is what will happen today, and I get 3 minutes. So first off, 10,800 and change people. We haven't made a blast for a while, but everyone's participation in our forum makes us better. We appreciate every one of you. If you guys would be so kind as to invite professionals that you know that are not part of our forum. I gave a talk yesterday to a Remax West office, and I was shocked at how few people were actually part of our forum. So there's a whole lot of other people out there that can join. Please feel free to invite. It obviously makes us stronger when we have good people who are joining and participating in every way. I'm going to give Greg his introduction, even if Greg is not here. Greg, are you here? I'm not sure if you're here yet. You there?
I'm here. We're just setting up here.
Perfect. That being the case, Sandra, just authorize him as a co-host, please. And I'm gonna make my introduction to Greg right now. So Greg Weedon, in my field, in the conveyance field, really we have two jobs. One is customer service, and probably 50% is customer service and 50% is law. You can't do one without the other, and you can't be competent at what you do without the other. In Greg's field, I would probably say it's about 90-10. That is to say 90% law, 10% customer service. But Greg, of course, defies that odd. Greg is one of those litigators who's available to us and to our group at a drop of a hat, always there to answer his calls and always there to pick up the pieces from failed deals. It's all well and good that myself and others on this forum can tell you what goes wrong and the consequences, but it's an entirely different thing to actually have to go through the process and take the breach forward through court. And so many of us, while we conceptually understand that you can go through a court process, don't actually understand what it involves. And many of us turn our attention to the people of this forum, many of whom are very capable litigators, but Greg has proven himself to be a stalwart in that regard. I know many of us use him for breach of contract, and so we figured we'd invite him on. And now that it is approaching 10:05, I will turn this over to him. Greg, feel free to share your screen for your presentation. I am recording this already, and I will thank Greg sincerely for his time, his attention, all of the numerous times that I've sought his counsel, which has always proven accurate and sage. I think you guys are going to enjoy this as much as I am, and because no one is here to hear the sound of my voice, I'm turning this over now. 10:05, perfect.
Perfect. The host needs to enable the screen sharing.
Oh, here you go. Let me just 1 second here. Make co-host. There you go. Okay, you're now a co-host, and now you should have your screen share.
Okay. Perfect.
There you go. We can see it. Perfect.
Amazing. All right. So I'll share this, this document, this presentation with everybody afterwards as well. So I'm assuming this recording is going to be available anyway. So thanks, Mark, for the introductions. Mark and I work together along with a lot of other realtors and lawyers in this group. Great resource. So thanks for coming today. I can see some familiar faces already. We're going to have, I guess, about 45 minutes of hearing my voice, and then we're going to kick it over to maybe some questions and answers if we have time. And feel free, Mark, to interrupt and ask questions as we go. No problem there. So just a bit of introduction for those who don't know me. I'm Greg Weedon. I run Weedon Law. It's a small law firm downtown Toronto. We focus mainly on real estate-based conveyancing and litigation work, which both go hand in hand quite often. I started off in real estate conveyancing for the most part for a good about 7 years. I transitioned into litigation pretty much right out of the gate. There's a nexus between a failed deal and litigating that deal. Usually the lawyer that represents the client for the real estate portion can't represent the client for the litigation, just because a lawyer cannot be a witness in the proceedings for litigation. But it's, it's a tool that every lawyer needs to have, to understand how to, to deal with a failed transaction and a breach of agreement. Unfortunately, a lot of lawyers are just not equipped, or they just don't know when to pass the torch over to a litigator. And sometimes, quite often, it prejudices the client at the end of the day. So we're kind of here today to to identify a breach of agreement, give you some trends of what's happening in litigation these days, in the real estate context. Bring you through a common breach scenario, consequences of a breach, and then we'll go through what happens during litigation. Like briefly, I'll try to summarize it up as fast as I can. But obviously it's a pretty complex and detailed area, which is constantly evolving. So at the end, I welcome anybody to give me a call anytime. That line's always open. My information's here, my cell phone lines and my business card, so you'll see it. So again, I'm available for anybody, and several of you guys can attest to that. Okay, so we'll jump into the trends that we're seeing in real estate, in litigation. Over the past 6 to 8 months, it really has blown out of control. It is cyclical. Every 4 or 5 years, we'll see a downward trend in the market and an uptick in the real estate based litigation. The last being 2018. The last, I would say, 6 to 8 months were markedly different. The real estate market, as you guys know, really fell off the cliff almost instantly. And what I would attribute that to, at least in part, would be like financing problems, like appraisal values, obviously interest rate hikes, and the lack of funds for rolling out of COVID. We kind of had a perfect storm, and the government was tightening up as well. Short-term rentals, it all kind of came all together, and everybody, there's various factors that played roles in it. But what we see, at least from transactional into the litigation perspective, is that the appraisal values, or at least appraisal companies, they tended in a hot market, they would just appraise the value as of the purchase price or the sale price. So you'd sell a house, and that would be, they would use that, the next person buying a house would use that comparable price as, that this is what where the market is. Well, as soon as, there's a thread that's being pulled in the market, the appraisal companies kind of they tend to, and in this case, they did get ultra conservative. So then they didn't use the comparable prices of what's selling next door. They undercut it by 15-20%, and then did that again, and then did that again. So the buyers that they purchased in late last year, November, December, up until about March, April of this year, with closings 60 to 120 days out, their value of their property decreased 20%, up to 20%. When you're dealing with $2 million property or $1.5 million property, it's 200, 300, 400 grand, and a lot of those people just don't have that money as a down payment. So, and a lot of buyers, unfortunately, leave financing to the last minute. So you're going to hear it, you're going to hear it in every, spiel. Get your clients in front of a mortgage broker that you can trust, right out of the gate. Get the appraisal done as soon as you can, because if the market slides and they have to reappraise it in the last day, your client's going to be left, coming up with another 100 grand on the day of closing, and and then we'll fall into my lap at the end of the day. So that's my an overview on appraisal values and lack of financing that is leading to a lot of breach deals. Requests for abatements, not so much very recently, but there was I would say 4 or 5 months during the summer where every single transaction we had, same story. Appraisal value came in low, buyer can't afford it. We need an abatement, we need a reduction in the purchase price by 100, 200 grand. I had one person, one lawyer asked me for a 500 grand abatement on a $2.5 million home. And I said, well, at the end of the day, why, if the market was hot, why would my seller ask you for another 100 or 500 grand if, the property value increased over that time? Obviously I didn't get an answer to that question, but, at the end of the day, it would be an absolute last resort for me to recommend to a client, to offer an abatement to close a deal. And that would have to be, a lot of different variables analyzed and being really in a tough spot. So we can talk about that later on if that's of interest. But buying before selling, conventionally, historically, it's fine. Today, bad idea. You're not going to want to buy a property before you sell your property. So make sure you protect your clients that are thinking about doing that, or don't advise them to do it at this point. It's too dangerous. In a downward market, you're going to be buying. You might be able. You might have a shortfall in your buy because of the appraisal value coming in low, and then on the sale, you haven't sold yet, so you might think your property is worth 200 grand, and then you try to sell it, and it's 200 grand less than you think. Now you have a 400 grand spread. And you've sold your house, you have nowhere to live, and you can't buy your home because you have 400 grand. You can't afford another 400 grand. So a lot of clients are in this situation, a lot. So, it ends up a domino effect. They'll end up not closing on their own home, their sale will fall through, and then they own a home at that point. So, any damages that are accruing, litigators will go after the property with a judgment. So it really is a tough spot. Don't do it right now unless you provide the proper conditions on selling your home first. But again, it's just too risky. I wouldn't even advise for it. Ghost deposits, we call it ghost deposits, but essentially you're just failing to deliver a deposit. Happens anytime. It's not necessarily in a hot or cold market. Predominantly it happens in more of a hot market. Someone will just go out and put that 5 or 6 agreements. They'll sign offers on offer nights for a weekend. They'll go on 5 different properties and they'll only buy one, but they might sign back 2 or 3 and then they'll just never show up with their deposit. This case, it's pretty the laws are very clear. Failure to deliver a deposit is a fundamental breach. You've heard it time and time again. Make sure you advise your clients that that's the case, and that they're going to lose, at the very least, the amount of the deposit they were supposed to put up as liquidated damages. But the severity is really that the seller has to resell it, and any discrepancy or delta between the sale prices are going to be put on to that buyer. So that there's that Pollard versus Perry case that that we did earlier this year. The link is at the bottom of this, and I'll put it in the chat later on. But that was the case there. The buyer, the defaulting buyer who failed to deliver the deposit, has a judgment for damages attached to their home right now for over 150 grand. So the severity is real. So because we're presenting here to realtors and not lawyers, I think it's important to advise you guys of what we can see and how what we would do as lawyers if we were in your situation, having an overall view of a potential litigation case, and how to conduct the proper due diligence and focus on prevention versus reaction. Okay, so most of the cases that we said deal with financial problems. The buyers can't come up with the money, increased rates, lack of financing, appraisal values. The problem is that a number of the cases that end up in our lap, they could have been prevented, by getting somebody in there earlier, as opposed to waiting, and or receiving bad advice. We could have got in there and mitigated the problem and come up with a solution. So let's go through how to potentially identify that and prevent that from happening. So obviously when before you're negotiating or while you're negotiating the APS, you're going to want a sizable deposit. All right, we see deposits range, different jurisdictions have different conventions on what they think is acceptable for deposits these days. In this market, like you should be between 5 and 8% of the value of the property. If they can't come up, if your client or if the buyer can't come up with that much money, then they can't afford to buy the home. Okay. So, put your money where your mouth is. More skin in the game forces a transaction to close. That just goes without saying. Obviously, due diligence in doing title searches, judgment searches against when you're acting for a seller, you're going to want to potentially run a title search. See if what the seller's telling you, your client's telling you that they only have one mortgage on title, or that they own the home by themselves, and it turns out that there's somebody else on title. Well, that's a problem that that's going to most likely kill your deal after you do all your hard work. So get ahead of it. Get a lawyer on board, or use Geo Warehouse. Get a title search done. Do a judgment search. Ask a lawyer how to do it. You can do it yourself. It's open to the public. It costs $11 to do a judgment search, and you'll see if your client has a judgment outstanding against them, whether or not they know about it or not. But it's something that you should do as a part of your due diligence to avoid problems, which usually are only identified at the last minute, and the deal will fall through because of it. Vet your potential buyers. As a seller listing agent, you want to vet the buyer's agent and vet the buyer as best as you can. If they're reluctant to give you information, in this market pass, to be honest, unless you're pretty desperate, but just try to get as much information as you can. Are they first-time buyers? Are they, if they're first-time buyers, they're going to be more inclined to, bail on the deal. But if they're, a family that's established in the city and they're downsizing, they're moving out, like their kids are older or whatever, and you get that kind of feeling that, they own a property, first of all, and they're downsizing, then, they're not going to, just jump ship and leave the country. So they have more skin in the game, and that's, a good indicator of, getting a deal done, just, naturally. Obviously, defects, anything that needs to be disclosed with the property, don't give the buyers a way out of these transactions these days. If there is an issue with the property, there's an issue on a file I'm working on right now. There's an encroachment agreement for the city of Toronto on title, and the deal looks like it may fall through because of it. It was identified in the MLS listing, but it didn't make its way into the agreement. So if in Schedule A it said that the buyer acknowledges there's an encroachment agreement on title, the encroachment agreement was provided to the city, in this case, the city of Toronto. And it called for the city has the option to remove pretty much a huge portion of this house if they want to widen the street. So the buyers are obviously concerned about that, they're balking on the deal right now, or at least they're asking for a significant abatement. So that's an issue that could have been dealt with if it was in the agreement itself, or if it was identified and worked through with a lawyer before, whether or not it's an issue or not, we haven't got there yet, but that's just a potential issue. A buyer may be looking to back out of a deal. So let's get ahead of it. When you're acting for a buyer, obviously just canvass their finances, their budget concerns. If they're scraping money together, borrowing money, if they need to borrow money from you to pay for the deposit, you can already guarantee that there's going to be a problem at the end of the day in terms of financing. Obviously there's exceptions, but just these are indicators. Work with a trusted mortgage broker. Everybody should have their go-to mortgage broker. I have 2 or 3 of them that I would trust implicitly. So find that person that's right for you and your clients, and you'll convert more clients that back and forth if you provide good service and good referrals. So that goes without saying. And obviously just manage your client expectations and get them in front of a lawyer as fast as possible if there's any issue. Okay. Now, litigation considerations after the APS is negotiated. Time of the essence clause, you'll hear that all the time. The time that you have to adhere to the timelines, deliver the deposit within 24 hours of acceptance. 25 hours is too late, you're in default. Don't rely on a text message saying, okay, yeah, you can deliver it late. Just get the deposit in. get your clients to have the deposit money ready to go before you put the offer in. Waive the conditions on time. Don't let these deals fall through just because of just pure negligence. That's what it is. Or at least that's what your client's going to argue. And if they get sued, they're going to bring you into litigation. Okay. So, communicate in writing all the time. I know that it's easy and, it's conventional to, and more human to, pick up the phone and at least, or back in the day, meet with somebody, shake their hand, meet the listing agent, co-op broker, and have conversations informally. If you're going to do that, fine. Just confirm what you talked about in writing afterwards, and just keep a memo or an email, because you never know when that conversation is going to be used, and if it needs to be used for the benefit of your client. So we'll get to that later on, the importance of that. But I can't stress that enough. Communicate in writing as much as you can. And then a simple request, we'll call it simple request to to delete somebody from title or add somebody to title, or not title, but to the agreement. Common, at the 11th hour, that's a red flag. But sometimes then for financing purposes, we'll say you'll get a request to swap the names of the parties on the agreement. Okay, so don't do that. Don't do the the conventional like insert name, delete the name. You're going to want to speak to a lawyer for sure. Guarantee that's pure legal advice there. Your client, you need to defer your client to a lawyer. I can tell you why. Is because I've had a case very recently where they swapped the names out at the last minute. The realtor did it. Insert delete name. Under the guise of financing, deal fell through the next week. The original buyer is claiming he's not a party to the agreement, so we can't go after him. The party that he put in was his daughter, who's an 18-year-old college student, has no assets. So now, it creates a problem that, we can't bring through the normal channels in litigation. It creates a huge issue of, credibility and a whole other complex legal argument that is going to, involve, the realtor at the end of the day for advising their client to do that, which would be negligent at the end of the day. Okay. Standard phrases, like the original buyer remains liable, that's fine. I've started actually, advising my clients to sign a personal guarantee, to have the original purchaser personally guarantee the performance of the contract. Just a one-page, guarantee, and there's no questions asked if they want it done. If they're not doing it for nefarious reasons, then they ought to do it. So I can share what that looks like with Mark later on. But it's it's something that I would advise. It's an extra step, but it protects you, protects your client, and there's only positives coming out of that at the end of the day. Okay. Extending closing dates, don't do it without at least your client's written authorization to do it, and and you acknowledging to them that it will impact their claim for damages if the deal falls through. Go to a lawyer, get the lawyer to give you advice. They have better insurance than you do. Example would be, I had a breach file, a few breach files, the same set of facts, where the realtor just advised, let's give them a month extension. So a month extension was sometime in August. The deal fell through at the extended date. And then, my client's suing for damages, but the damages that were, that we can't capture the damages that happened during the extended period of time. So that's a huge problem, because, there was a lot of damages that were incurred at that time. My client had to go get bridge financing, private financing to save a deal. There's about 40 or 50 grand in damages now that, we've lost the ability to even deal with. And the realtor is going to have to get brought into it because for advising my client, to just arbitrarily extend it without any terms or conditions. So we get your client to a lawyer, safest bet. I can't stress that enough. Okay? And if your lawyer is not willing to give that information or that advice, a lot of lawyers are just like, that's not what I do. That's fine for them. That's great, but my advice is find a different lawyer. If a lawyer that has a bit more, maybe time on his hands, or that's a bit more dedicated or a bit more competent to deal with a situation like this and provide the service that your clients are going to need from beginning to end. That kind of goes without saying, but it should be repeated because we see it a lot. I'm sure Mark and other lawyers that are here today can attest that there's a lot of bad lawyers out there. So I'm not going to throw anybody under the bus, but it just a lot of the deals, a lot of the transactional problems that could have been avoided quite easily that end up in my plate for litigation just could have been dealt with differently, and they wouldn't have ended up on my desk. So identifying a breach, we've kind of touched on a few of these issues already, but it's a good idea to kind of go through a few of them that maybe you think is an issue. If you have an indication, or if you have a gut feeling that there's a problem, there probably is, to be honest. So talk to a lawyer about it. Common indicators or red flags, like if the buyer's not retaining counsel, like the title search date comes and goes, there's no lawyer on board, you can't get a hold of your client, or the other client, buyer client, or the buyer, sorry, just doesn't do a title search. Your lawyer, the lawyer for the seller, is going to be like, what's going on here? Probably going to give you indication that there's an issue, but that's definitely a red flag for sure. If you don't have any communication with the other agent, the co-op agent, drops off the face of the earth and stops communicating with you altogether, that's probably a bad sign. If the buyer's not conducting their site visits, if you're going to buy a $1 million, $1.5 million house, you're going to probably want to view that house, take measurements. You're going to be excited to buy that house. If they're not viewing the house, or they're taking advantage of their viewings that are in the APS, a huge red flag. I can tell you that most of the cases that we deal with, like where I can pretty much tell you that if they haven't done their site visits, they're most of the breach files. Let's just say this: most of the breach files that come in from on our plate, we know pretty soon in the transaction that they're not going to close the deal. So we can kind of mitigate damages from that period of time onwards, and and we don't leave it to the last minute, because oftentimes that I get the information after the deal falls through, and I say, well, look, that was an indicator. You should have got before a lawyer earlier. But obviously your request for extensions, vendor take back mortgages, changing names to the agreements, these are red flags as well. Not necessarily a complete indicator that it's going to cause a breach, but it's an indicator that there's financing problems. Most definitely, no one's going to ask for an extension or change names or vendor takebacks if there's not a financing problem, which is obviously a huge indicator for a breach. At this stage, it's critical to getting the deal done to identify these issues and get them before a lawyer as fast as possible. Be proactive, not reactive. And then there's prepare them for the worst case scenario. You can be a pessimist, but it doesn't matter, because if your gut feeling becomes true, then at least you prepared your client and you protected yourself. At the end of the day, like, we'll have a lot of clients coming in when the deals are on the rails, and I'll be able to pretty much identify that there's going to be an issue here pretty quickly, and that whether or not they're going to close or not will depend on varying factors. But where there's smoke, there's fire, generally, especially in this market. So sometimes it's good to be a pessimist. All right. So, and obviously just finding the right lawyer. I'm not going to prop myself up here, but there's tons of lawyers out there that are great. I can see a few of them that are here today that I recognize. Just get them to the right lawyer and get the deal done, or prepare your client for the worst case scenario. If you don't, and if you are dealing with a lawyer that just is just churning out complete volume, doesn't mute the clients, isn't available, you never get a hold of them, you're probably going to end up prejudicing your client considerably for saving a few $100 on legal fees. You might want to get them to somebody that can help them out in situations that go south. Because I can tell you that there's certain lawyers out there. There's a lot of lawyers out there that that just don't do litigation, and they won't even tell you that there's a problem until the 11th hour, and they knew, or they should have known, that there was a problem, but their clerk didn't communicate it to you. So just get them to somebody that you trust. that can problem solve, manage expectations, and and get an action plan, because that's generally what needs to be done. And if their deal can be saved, if you guys want to get paid, so our main goal is to increase the likelihood of getting the deal done and avoiding litigation. So we've had we've been very successful over this past summer in saving these deals and avoiding litigation. So it did about 25% of our files that didn't even go into litigation. We've closed them, and the clients are more than happy. We're able to get our foot in there early and come up with a solution. It doesn't end up in court, which is not fun for anybody. Okay, so we've been through identifying breaches. So now let's say we're in a breach. We're in a breach of agreement. What is a breach? Very simple. Someone doesn't come through with the agreement, doesn't honor the agreement, or communicates an unwillingness to follow through with an agreement. So and it's called a default, a breach. Cause of action, multiple different ways of putting it. But either way, we're looking at now the consequences of breach, which is good for you guys to know, because your clients are going to ask right out of the gate, what happens now? Who do I go to? What happens to the deposit? Where are my damages? Varying different degrees of questions you're going to get, and you should have the tools to answer those questions, at least to a certain extent, and then you can help find the right lawyer for your problem. So damages in general, the overarching principle is to restore the innocent party to the position that they would have been if the deal or the contract was performed. So the main category of damage here that we see on buyer breach files is the difference between the two sale prices or purchase prices. So for example, I had one client sell a farm property 3.2 million in February. We had a breach, resold it in June, I believe, for 2.2 million, so over $1 million in damages right out of the gate, right between the two sale prices. That's how much the market shifted, at least for this type of property in this area. So that's generally the highest category of damage would be the difference between the two sale prices. In a hot market, it might be a negative difference. They might turn around and resell it for higher. In which case, we probably wouldn't be needing to talk about it because there wouldn't be litigation. But either way, it's relevant at any time, because you never know where the market's going to go, and you never know what the resale price is going to be. For instance, the Pollard and Perry case that I referred to earlier, that was in the height of the market last year in August. They sold it over a weekend, an offer presentation day, and the original buyer overbid for it, and then defaulted the next day, and then they resold it 2 or 3 weeks later for 140 grand less. So even in the height of the market, you're still seeing damages in exceeding $100,000. So it's still very relevant. Aside from that category of damage, we're looking at any out-of-pocket expenses incurred flowing from the breach. So interest on your mortgage, taxes, insurance, property insurance, moving costs, legal fees, you name it, anything that you've spent on that property during the time that it should have been closed. So from the original closing date to the new closing date, that period of time, that you can capture every sunken cost in that you spent in the property. So maintaining the lawn, for example, so obviously there's different variables in there as well, but we provide like a damages worksheet for our clients just to kind of track their damages and give them an idea of what type of damages they should be looking for as a seller. And then they track it and they give it to us at varying stages of the litigation, so we we can follow it with them, and we can keep it all kind of concise. So that's just one example of what we do. And that's something that you guys should be recommending as well to your clients that are in this situation, is to keep track record of everything that they can, keep a file on their computer, a memo or a spreadsheet, and just pocket everything that you can, because that is what we're going to be going for in terms of evidence later on. Domino effect, I briefly talked about it earlier on, but if conventionally you're selling and then you're buying with the sale proceeds. So if your sale falls through, generally you're not going to be able to buy. Some people, a decent amount of people are actually fortunate enough to be able to be in a position where they can actually buy without the sale proceeds. But we would need more lead time, so don't have the transactions closing on the same day, because or at least we can identify the breach on the sale side early, then we can call the breach, and we can get private financing set up, and put a collateral mortgage over the two properties, and then we can afford to buy the second property. At least we can afford to buy it today. Now, whether or not you can afford to maintain both properties is a different story, but I can tell you that if you breach, if your sale breach causes you to breach the next deal, it's going to be you on the line. Okay, like for that deal, like for that breach, the breach that your buyer, when your client's buying that second property, they're going to be on the line for that breach, because it's not the seller's responsibility at that point. A common misconception is that the defaulting buyer at the bottom of the domino or the bottom of the ladder, is going to pay for everybody up that ladder. Okay, but that's not the case. It hasn't been litigated yet, at least as far as I know. It will be very soon, just based on the fact patterns that I have over. It will be before a judge in Ontario very soon, but I haven't seen one yet. Where the original defaulting buyer is going to be paying for the defaults up the chain. The reason being is it's too remote. Like the original defaulting buyer is only going to be responsible for damages that he could reasonably foresee, or he or she can reasonably foresee, and whether or not it's reasonably foreseeable to pay for people that you don't even know about all the way up the chain is a question that I can't answer, but we will get an answer pretty soon. So it would be important to, when you're in a situation in a downward market, your client's buying and selling, communicate with the realtor on the other side before they put the offer down. Say, hey, by the way, my client is buying a home, okay, and they need the sale proceeds to buy it. So that's why we want to stagger the price, stagger the closing dates around the same day, because of that. Now you've just now captured it, like the domino effect, and now your client can go after the damages if that deal falls through, because the buyer knew about they were using their purchase proceeds, let's call it, to pay for the seller's purchase. That's just an example, a nuance, but it's a common misconception. So I felt that it's important to highlight that, at least today. And keep diligent records. I've already talked about it, but keep records of everything, because we're going to need that evidence down the line. Deposits, common misconception amongst realtors and lawyers. Still, I still get lawyers saying the same thing. If there's no deposit, there's no contract. I don't know where that's coming from. Maybe a common sense. If you're doing a deal like informal deal, like a GD or something like that, maybe that makes sense to you. But in real estate, the deal is when you sign on the dotted line. The deposit is one of the first performance of your obligation under the agreement. If you fail to deliver the deposit, you default. It's a fundamental default. So raise awareness about that. If you're a broker of record, teach your realtors and your salespeople that needs to be reinforced, and to educate the other side as well, because quite often they just don't know, and they're advising their clients, and then it ends up on my plate, and I can tell you it's a guaranteed chance of success at the end of the day. if that happens. So, if they're going to be, entertaining extensions of closing dates, we recommend these days that if you're going to be entertaining an extension of a closing date, have the buyer agree to release the deposits to the sellers right out of the gate. Obviously get the lawyers involved at this point, but what's commonly happening is buyers are defaulting, and then they've asked for an extension or two, and in those extension terms, we could have negotiated a release of the deposit or additional deposits. That incentivizes a buyer to get their act together, find the financing, and get a deal done. Otherwise, they're going to hold that deposit as leverage over you, and it happens every single time. Every single time on a file that that I haven't managed from during the actual breach process, there's a deposit sitting with a realtor that's still there, and it's been a year or two, or however many years. It's just eating away, and the defaulting buyer is refusing to release the deposit because they say we'll only release the deposit if you sign a mutual release. You're going to hear that every time. So get ahead of it. You force that conversation, or eliminate that conversation altogether by having that deposit released. And don't worry, if the deal does close, you'll still get paid. Your commission is due and payable by the seller. The lawyer is obligated to direct that money to you. So just because the deposit's not sitting with your trust account or in your trust account doesn't mean you're not going to get paid. But it puts your client in a much better position. And if it does go to litigation, then then they have money to deal with, to mitigate their damages and pay for litigation costs. Whereas if they don't, then they're really in a tough spot, and they might not be able to afford a lawyer, and they might sign a mutual release, and that will be the end of it. So, and then let's say we do get a judgment, enforcing your judgment. It's a major consequence, obviously, of breaching a deal. If the buyer has a property, or if the defaulting party has property, then the judgment will attach to that property as a writ of execution, and that buyer, that defendant, won't be able to sell that property without paying out your debt, without paying the judgment out. So it secures your judgment, almost guaranteed. So if someone comes into my office and it's a breach scenario, the first thing we'll do essentially is assess whether or not they have a property, because if they do, then we can use that leverage right out of the gate, and that pushes anybody to really figure their stuff out. Because if they lose, if they default, then when they lose, and then when we get a judgment, we're going to force the sale of their home, and they're going to be in a much worse position if they have to sell their home, pay out our debt, and then and then they're going to be homeless, or they're going to be renting, and they're going to be in a much worse position if they had to just went out and found private financing, or like pulled on the heartstrings of family or friends to get that extra 50 to 100 grand for a temporary basis. That just goes without saying, but it's important to know, obviously, the major consequence of losing a breach file. So we'll get into litigating it. This is our last few slides here. It's obviously a complex and very detailed thing to summarize, but what we go through in the initial process, and then from beginning to end. If I was going to have a consultation with a client in a scenario where they're a seller and the buyer breaches, this is kind of the overview of what we're going to discuss during that consultation. So it's good for you guys to know what that initial consult is going to look like. So the initial step that we do is we do an asset evaluation or an assessment. We go through the cost benefit of litigating. The problem is at an early stage, you don't know what your damages are, so don't even think about signing a mutual release, because you don't know what you're going to resell the property for. It could be 50 grand, it could be 100 grand. You're not a magician, you don't have a magic ball. We just don't know. You're not qualified to appraise the property, so don't even entertain a mutual release, because the damages can be substantial from month to month, and buyer to buyer. So Initially we're going to get in there, we're going to assess whether or not, the buyer has property, whether or not we can use that to leverage, their position and try to revive or save, like salvage the transaction. That's our first step in any of these files. So it's important to get us involved, as soon as possible. And the word litigation doesn't even need to come into play in that initial consult. So generally, I won't even discuss if the deal is still salvageable, or at least I think the deal is salvageable. I won't even use the word litigation. It freaks people out. I'll say we can discuss that at a later date. Let me just try to focus on getting this deal done, getting everybody paid, and saving livelihoods essentially at the end of the day. Because if it goes into litigation, it pushes it into litigation, then someone's going to pay for it, and someone's going to lose their house, and it's not going to be fun for anybody. So it's really just a cost benefit analysis of weighing the options, the cost of litigation, the time of litigation, and whether or not we can figure out a solution that avoids it altogether. So let's say we're already in a breach. Sorry, it's bring your dog to work here today. So let's say you're already in a breach situation. You have a duty to mitigate. So as a realtor, we should be constantly telling our clients that we have to mitigate damages, we have to relist the property immediately, and we have to keep a dialogue open with your client in writing at every stage. Okay, so relist, we always recommend to relist the property at the same price that the purchaser paid for it, all right, or was supposed to pay for it. And conventionally that, or at least historically in case law, that's been obviously the preferred route. It's also completely acceptable to relist it at the same list price that it was listed at before. Okay, so you can either choose between the two of them depending on where you are in the market, depending on what the buyer originally agreed to buy it for. But definitely as a baseline, one of those two options is your best call. Obviously consult with a lawyer before you do anything. You don't have the expertise to provide mitigation advice. So if you're going to be at this point, we jump in and we consult with you and the client at these stages. They're very important stages of this. Mitigation is the only defense that a defendant buyer is going to have in a breach scenario. The only defense they're going to say is, well, you guys didn't mitigate your damages properly. You relisted the property too late, or you listed it for undervalue, or you sold it, you reduced the price too much, too often. Okay. Now the courts are not going to, scrutinize that very carefully. But if they raise evidence that, questions whether or not we mitigated properly, then, our evidence is going to have to, be polished up. So what we do in this case is, we have, preset like emails that we recommend that the realtors communicate with their clients in the scenario. An example here is, Dear John, based on the market analysis and review of comparables in your area, it's our opinion that the property is priced too high right now. Here's a property next door. Here's the MLS printout. It sold last month for X value. We recommend that that we adjust the price based on square footage, whatever, and we should list the price at this price to market the property effectively. That email, every time you want to reduce the price, is what we'll be going to be using later on in affidavit evidence, and it's the most important evidence we're gonna need. Okay, so again, consult with your lawyer. If it's me that's managing the file, we already have a system set up that will help you through the process. The next stage is after we kind of assess the issue, and we deal with mitigation. The next stage is actually litigating, drafting a statement of claim, which is an action, a lawsuit, and then the defendant has 20 days to respond to the action, or they're noted in default. But I'm not going to go too much into that. The most important really element here is the summary judgment motion procedure, which is a procedural tool that's used in certain cases to obtain a judgment without having to go through the regular trial procedure, route. And it is right for real estate breach situations. Normally the facts are always very similar. Buyer can't show up, can't have the financing, can't close the deal, a firm and binding deal. There's really nothing else to argue except for mitigation of damages. And the courts have been, they accept that a breach of a real estate transaction is appropriate for summary judgment, which is great. So I'll tell you why in a few seconds. But the test, briefly, is that there cannot be a genuine issue. There can be no genuine issue requiring a trial. Okay, so if there is an issue in dispute, if there's credibility, a he said, she said, or there's a defect in the property or misrepresentation, that's real and substantial. The summary judgment procedure will not be effective if the judge will not grant you summary judgment. Because a trial procedure, it has in-person evidence. It's a very long procedure of examinations, and the judge, it'll be over multiple days. The judge will hear the actual evidence from your mouth as a witness. In summary judgment proceedings, it's only affidavit evidence. It's only on the written record. The only person talking at the motion is the lawyer. Okay, so it's efficient, like very efficient. We can get an expedited resolution or judgment, quickly. I'll go through what the timelines are shortly. I know we're running low on time. It's cost effective. Trials, are very expensive. Summary judgments are, a fraction of that cost. For a motion, we generally have two affidavits that we rely upon: the homeowner's affidavit, which will speak to damages. So, like the two agreements, the difference between the two sale prices, the tax bill, legal bill, maintenance bill, etc. The homeowner will speak to those damages and submit those damages as affidavit evidence, and that's what we rely upon to tally up the total damage. For realtors, we always have the realtor do an affidavit as well, which only really generally speaks to the listing efforts and the relisting efforts and mitigation efforts. Because you guys are on the ground, you guys are the ones communicating with potential buyers or potential agents. So that communication and that effort, that marketing effort, is very important for your client during litigation. So keep an eye on that, because if you are in a situation, you're probably going to get a request from the lawyer to be a witness, and it's just going to be an affidavit, a written statement. Timelines, misconception in terms of how long litigation takes, or generally can take, and that's predominantly because it's everything except for real estate based litigation can take very long time. If conventionally years, it wouldn't be uncommon for trials to go, for a trial hearing to be like 4 or 5 years before it even hits trial. So, and obviously that we have backlog. There's a conception that that there's been so much backlog from COVID-19. Well, the good thing about COVID-19 is everything now is electronically filed. Everything is conducted on Zoom. We can have 4 or 5 court appearances a day, as opposed to one day sitting around doing, waiting for the judge to be available. I've had a judge on a dock in Muskoka hear a case for an urgent injunction motion. So access to justice is real, and it's there, and everything is speeding up considerably. So real estate litigation is ripe for summary judgment. We're able to to commit to a timeline for a judgment within 8 to 12 months. Okay, so conventionally, you hear a lawyer say, "Oh, it's going to be years of litigation. It costs X amount." We can commit to a beginning to end judgment within 12 months, or sooner. We're moving up that timeline. It looks like on a few files from earlier this year. So obviously, if summary judgment isn't available, then we're in the regular trial route, and the time will be at least a few years. So costs. So major factor, major question for your clients. They're going to ask, what are the costs of litigation? How much is it going to cost me out of the gate? What's the initial retainer? It all depends on the facts of the case, and where you are in the case. Generally we're looking at around 10% of the value of what you're arguing about. It's not a hard set number, but just based on a review of the files that we've been working on over the past few years, it kind of comes out to about that. So if you have, a case where you're arguing, a $200,000 argument or a judgment over, then you're probably going to spend around 20 grand. Obviously, give or take different variables and how cooperative the other side's going to be, and how many motions have to be brought in between to get there. But we would estimate at least for a summary judgment stream, the streamline approach, between 15 or between 20 and 25,000 beginning to end, not necessarily all up front. We take it in stages, but we're able to do it much less expensive than a regular trial route, because a trial, 4 or 5 day trial, 10-day trial could cost you 150 grand just the trial alone. So you put those two together, and it's a pretty cheap process and pretty quick turnaround in comparison to the normal stream. And obviously invite you to take a look at the cases below, the Scott and Forjani case, and the Pollard and Perry case, and take a look at the cost awards in those ones. You'll see that the cost awards are substantial, to the point where they got paid over 70% of their legal fees that they incurred. They got paid that back in costs and damages. So that's an important part to tell your clients, that you might have to fork up 25 grand, but you're going to get 18 or 15 grand back at the end of the day, and you're going to get a judgment for X amount of money. So important factor to go about. Lastly, the realtor's role. We've probably covered a bunch of these already, but mitigation is your forte. This is your advice to your client to how best to mitigate. And that just it seems daunting, but it's more so where the market's at, communicating with your client, trying to get the best deal on the table. Those are all mitigation efforts. Marketing the property as best as you can, being reasonable in your attempts. That evidence is very critical. Keep an eye on the defendant. If they have properties, flag that property if it's up for sale during litigation. All right. If we have to bring an urgent injunction motion to stop that sale from happening, or to preserve those sale proceeds from a buyer trying to liquidate their assets during a default, we can jump in pretty quickly. But we can't be in charge of keeping an eye on all these properties that these buyers own. So that would be a good idea as well to assist your client. Collect, compile, all your affidavit evidence, all your evidence, keep it in a folder, keep a list of it, keep it, a memo that you can work with, because you guys are the boots on the ground in terms of, the communication between the parties, and your evidence is very important. So, you do play a very important role in this process. So, I can't stress that enough. So we do have the 2 cases here. Actually, there's 3 cases that went to the Court of Appeal on the Scott Forjani one, but it's the same thing. Summary judgment cases, breach of a real estate transaction. Take a look. You'll see the crazy defenses that people try to raise, and it's still, those cases are still ripe for summary judgment. So it's a good indicator and a good case to send to your clients, or a good case to send to a defaulting client, to say, hey, this is what the consequences are if you go down this path. Okay, that's enough for me talking. Mark, do you want to open it up? I know we're late here, but
totally. What I'm going to do
a few more minutes.
Totally. What I'm going to do is this. There's a lot of questions in the chat. I've been answering some of them, but Greg, maybe you can take this opportunity while I'm speaking and just kind of peruse them for a little bit, and start answering those. Guys, we've been an hour. I think what we'll do is we'll keep this open for an extra 15 minutes for questions. Anyone is welcome to hang back, but the substantive presentation is now done. Having said that, the questions are often more enlightening than anything else. So Greg, do you have another 15 minutes to just answer people's questions while we're here?
Yeah, I do. Yeah.
Okay. So, if you go up through the chats, you'll just see tons of questions, and I've been answering some, but do you want me to pick, or do you want to just answer and read?
Yeah, if you can pick for me, that'd be great.
Sure. So first off, I'm going to start with Anna Stanky. Should the APS be written so that a buyer would understand that a seller could be expected to be using the funds from the sale to proceed with their own sale, so it becomes a discussion point of damages in litigation?
Sure. Why not? might as well. If you can put in there the buyer, the buyer acknowledges that the seller's using the proceeds to buy a property, why not? Just an acknowledgement, right? I mean, that's all you need. Even if it doesn't have to be in the agreement, it might scare away a buyer, but at the end of the day, if it scares away a buyer, then it's probably not the right buyer to have an agreement. So I would say you can, whether or not I recommend it doesn't really matter, but it could be good advice. Yeah.
Perfect. Okay. Steffi, I answered your question in the chat. Sue, so you can ask for damages before closing if it's breached and you have red flags. So, can you ask for damages before closing if the agreement is breached and you have these red flags? I think what's being asked by Sue is if there's anticipatory breach, can you proceed or can you ask for damages?
You can, if there is a breach before the closing, then that's the date of the breach, and any damages flowing from that date onwards are real damages. I'm not sure if that answers the question or not.
That did, I think. For Stacy, Wilcox writes, if there's a mutual agreement in writing through an amendment to extend a closing date or assignment of the agreement of purchase and sale to change the name of the agreement, would this not protect both sides? I think, remember, these questions were dating back to when you were talking about the amendment issues and everything else. I'm
right.
just various parts of the talk.
Would they not protect both sides? So if there's a mutual agreement in writing through an amendment to extend the closing date, would that protect both sides? I mean, it only really is going to protect one side, the person that asked for the amendment or the extension, right? I mean, so I would say, that I would say that the clause should be that, that we'll extend the closing date. However, if the buyer fails to close the deal on the extended closing date, then then the original closing date shall be held as the date of the breach, something like that.
Yeah, that's fine. Oliver, I'm going to answer your question now and just give Greg one break. Your question is, should your client entertain an extension of the closing date, deposits held ought to be released directly to the sellers immediately. How can this be done? Since the deposit is being held in trust with the real estate brokerage, are we not allowed to touch trust funds prior to closing? The answer to that, which I will speak to because I've dealt with Rico on this point, is not that you cannot you cannot touch trust funds before closing, but rather that trust funds can only be touched in one of three instances: a court order, completion, or mutual agreement by the parties. The contract, the agreement of purchase and sale, is the mutual agreement between the parties. And technically, if you have a clause in there that directs how trust funds are to be used, that would be appropriate by RICO standards and not in violation of a brokerage's obligations. Now, that is different than the way brokers of records are ready to deal with their trust funds, because their trust funds, they believe they need a mutual release. And so it often takes some explanation on letterhead from a lawyer threatening to sue to explain to them that what is actually required is mutual agreement, and a mutual agreement is in order. The broker of record, because this is out of their bailiwick, generally then has to consult with litigation counsel, who then affirms that understanding, and it is only then that they usually release it. So to your question, if we put this in, can we do it? The answer is there's usually a bunch of procedural barriers because broker of records are not comfortable with it. But that is different than what is legal, and it is perfectly legal to, based on the agreement of purchase and sale Schedule A provisions, have a mutual agreement that directs trust funds in advance of closing. I hope you don't mind, Greg, that I took your file there, but I've dealt with Rico.
No, completely fine. In files where there's an extension request, we, like what I was getting at there before was that, we would, as a term of the extension, we would say that, that any deposits that are already with the listing brokerage, and I'd name the listing brokerage in the paragraph, are, shall be immediately released and directed, and this paragraph shall, constitute an irrevocable direction authorization to the listing brokerage to release it to the seller, which will be credited to the buyer if they close the deal at the end of the day as a deposit. And then even we have run into problems where the broker of records will say, that this is a settlement agreement, and we're not following this, this paragraph, even though the paragraph's completely legitimate. So we've gone the extra step in our extension agreements that we ask for that. we actually attach as a schedule a written direction, like a direction rate to the listing brokerage signed by both parties that state that the deposits that are held on account are to be released to the seller, like without condition as of today.
I do the
That might
same.
answer the question.
Yeah, I do the same in my extensions, because it just makes things easier to get around all.
Makes things a lot easier. Yeah.
Okay, Matthew Gibson, who's a lawyer himself and has presented for us, asks an interesting question. From a mitigation perspective, if the original buyer has breached, advised they won't be closing and refuses to bring in a deposit, are there other offers, and there are still other offers on the table? Does accepting the second best offer make more sense than relisting? Are there any risks to the seller when they pursue their damages via that mitigation strategy?
Good question. I mean, look, there's too many variables to answer that question. It depends on what the price is, the second best offer, right? I mean, how low is it close to the same price? Like, if it's not close to the same price, they're going to rely on, the realtor's evidence to say, hey, where are the comparables? Like, you're going to have to really document that advice to your client to say, well, this is a good price considering where the market's at. I would recommend taking, this option because of these comparables in the property, like in the market, but again, if the second best offer is, a lot less than the offer, then, we're kind of playing with fire here. It might be questioned as a mitigation problem. But at this, because you're not relisting it, you're not remarketing it, you're cutting out a whole, pool of people that may be interested in paying more for it. It's an argument that would work against us, but at the same time, I wouldn't think it's going to be scrutinized too much by a judge. So I wouldn't be too concerned as long as the numbers, are close enough to each other. I would still give the advice to take the second best offer. But again, disclaimer on that one. So talk to a lawyer about it.
Okay, Tara White asks, how long do judgments get, how do the judgments get paid? How long does it typically take to receive a judgment in full?
Good question. It could be short, it could be long. It all depends on whether or not the defendant has assets, right? I mean, if they have no assets, then, it could be a long time before that judgment gets paid. If they go bankrupt, they might not get paid at all. If they have a property, then if you have a judgment that attaches to a writ, a writ that attaches to the property, then you can generally get a sheriff to take possession. You can sell that property. Generally 6 months, or I'd say 6 months to a year after the writ's filed would be a good timeline to enforce that judgment against that property. Meanwhile, your interest is accruing on your judgment, and your costs are all being covered as well on top of the judgment. So it's just a waiting game at that point. And you can, at that point, leverage, some sort of a settlement against that party, get them to refinance their property, pay out a good portion of your judgment, and save them from having to sell the house, lose that property. So it all depends on the situation, and how liquid their funds are, what they have funds, or if they have property. So it's a loaded question, but it'd have to be very fact specific to answer that.
All right. Just because this gives you an opportunity to self-promote, is Greg taking on new clients?
Yes, I am.
That was a freebie.
Yeah. No, I'll let you answer that one for me, Mark. But no, I'm always taking on new clients. I always say I'm not. But as long as the client, on the real estate side, we for sure, definitely we take on new clients in real estate transactions. We have a great team here that handles predominantly the conveyancing side of the business. In terms of litigation, I'm generally only taking on cases that fit into a very small category of real estate based litigation right now. Otherwise, I'll have to deviate from that, and the system will kind of fall apart. So we're able to take on the volume of sellers. We're able to represent sellers where buyers have breached, because we have the templates, we have the system in place, and we have the commitments to a certain timeline, and we know the law like the back of our hand, so we can get that result for you guys quickly. But as soon as we start deviating from that and we start dealing with, other matters that are a bit more complex, then, we would refer it out most likely to a colleague of ours, or give it to a junior. But
Okay, I'm going
yes,
to do,
we are taking
I'm gonna do one last thing. So I'm gonna make a hard stop here at 11:20. Greg, I'm gonna open it up to verbal questions here for the remaining 8 minutes. So guys, whoever wants to, please unmute yourself, ask your questions, and 11:20 we'll make a hard stop.
Hi, Greg. It's Tara again.
There.
I was just wondering if, just in follow-up to your answer there, how do we determine if the other party has any assets in which to litigate for? I mean, we're looking at expensive costs with a return of, say, 70% if they have money. Like, is there a certain point where we check to see if this is worth doing from a breach standpoint on the other side?
That's my first thing I do when I get onboarded, even if we're not even discussing litigation. Like if a deal's on the rails, like, and even when we're negotiating extensions, like I'll do an assets like search for sure. That way I can, in my extension letter, I can reference that the buyer's property that, that they're about to, compromise if they fail on the agreement. So we do it like lawyers. I would recommend doing it as a lawyer for sure. Any leverage you can give your client to get a deal done, and avoid litigation, why not? As realtors, I'm not sure, what tools you guys would have to do to property searches. Geo warehouse. You can obviously do searches by last name. Talk to a lawyer about how to refine those searches and cast that web. Cast a larger web. There's tricks and tools to help you in title searching to locate assets in different jurisdictions, but I'm not sure if you can search all different jurisdictions like one by one, like all LROs, or if you're confined only to specific ones, depending on what type of account you have. But we can search them all. So
if I can add to that, when you're doing an
Yeah.
offer, if you have multiple offers, always do a search to see if the two offers are very, very close. Do a search to see if one of those buyers owns property and accept their offer. That way, at least
Yeah.
from the get-go.
for sure, especially in this market, right? I mean, why not? $30 to $35 to do a search. Put your client.
Well, Geo Warehouse will show up anything for free for us.
Oh, well, okay, great. Oh, really? Okay.
I have
Yeah,
a
it's good.
question.
Hi, Greg. Oh, sorry.
So my question is, if the buyer defaulted because they didn't bring the deposit and the property is relisted and there's no new offers, some time has passed, what else can be done in terms of mitigation, or should the seller consider discussing with the litigator at this point?
Well, after the deal's breached.
Yeah, after the deal is breached, and the property is
Yeah,
relisted for mitigation.
There should be a litigation lawyer already giving advice.
Got it.
Sure.
Thank you.
Yeah, I mean, like even before it breaches, definitely after it breaches, whoever, hopefully, yeah, the advice on mitigating your damage is relisting the property. There's different variables there as well, right? What I say here today, definitely needs to be refined, on a fact by fact basis, right? So, definitely get them in front of a litigator for sure. I do consultations all the time. I don't charge for them as long as they don't go over an hour. So my phone's always open. My emails are always available. So it's not hard to reach out and get that advice, and and we can kind of hold your hand through the process, but definitely for sure as fast as possible. I guess one other point. What if the property is for sale and you're having problems selling it? You should probably think about renting it. So you should there's case law that says that after a certain point in time, I don't know the exact date, but it's all, again, very subjective. At a certain point in time, it's expected, and the seller has an obligation to mitigate by renting the property out, which kind of goes against the principle of being able to market a property with a tenant in it. It's going to be hard to do, but at the same time, the costs associated with your mortgage payments and everything like that goes along with the property can be offset by renting it, And, I have a lot of clients that are right now having, a handful, probably 15 or 20 clients right now that are in a situation where they're still trying to sell their properties from earlier this year. It's been listed for 6 months, and they're still not willing to take a $400,000-$500,000 hit on their resale, probably mainly because the buyers don't have assets. We've done an asset search, and it's not fully worth it, to get a 400 grand judgment that we can't enforce. So I'm telling these clients to let's rent the property. If you can afford to hold that property, rent it, and refinance, weather the storm, and reevaluate in 6 months to a year, and then come back to me, and we'll continue the discussion. You have 2 years to sue that individual for breach, for any sort of cause of action. So it's something to consider with a litigation lawyer if your client's in a situation like that, for sure.
Hi, Greg. It's Stephen here. Thank you so much for the informative session. Just wanted to ask you, going back to the extension, and you mentioned that it's a good idea to have the deposit released to the seller. Can you sort of go over the benefit of that, like the importance of releasing it immediately to the seller?
You take the leverage away. Like the seller will then have 100 grand that they can work with. Right.
Okay.
They'll have the 100 grand that they can work with, that they can mitigate their damages if the deal falls through, right? If they're asking for a month extension, and they're in today's market, there's a high chance of the likelihood that the deal is going to fall through if it's not massaged through that process. So
the money
actually
doesn't go to the lawyer's trust account, like the seller's lawyer. It actually goes to the seller.
Well, it could, yeah. I mean, generally it goes to my account first, but then it can be released to the seller immediately.
Oh, I see. Okay, thank you.
Right. So then you don't have to go to court to
That makes
argue
sense.
over the deposit anymore, right? You can get that deposit in advance, and it takes the leverage away, and now you have money to work with during litigation, and potentially save yourself. If you have to buy a home, you can use that as a down payment. You can mitigate your damages considerably.
All right, last
then,
question.
yeah.
Last question. Let's give this to Kevin, who's been having his hand raised, which we're going to
thank you. Yeah.
behavior. Kevin,
Thanks, Mark.
over to
Yeah.
you.
I like to use the features of Zoom, but Greg, earlier you said that in this kind of a market you shouldn't buy first, you should sell first. But what if you bought with conditional sale of the buyer's property in a market where we can hold back on offers, have a short conditional period, and if we sell it 8 or 9 days later, then we can firm up. And if we don't sell it 8 or 9 days
that's
later,
completely
there's
fine.
no deal. Yeah.
That's
I know it's a
completely
real
fine.
estate tactic more than a legal question, but that would be.
Yeah, look, it's completely fine. If you're protecting your client, which is all the whole purpose of my talk, right? Is to protect the client. If you can get out of the deal that alleviate the potential breach, if your deal falls through on the other side, then kudos to you, right? So yeah, I'd recommend it. It's just not really legal advice. It's more so business advice, but it works for sure. So
yeah, and we'd still be within the conditional period. Yeah, so that's the benefit.
As long as you're in the conditional period and you follow the realtor's advice on waiving it properly or not waiving it, and yeah, I have no problem with it.
All right,
Thank you.
guys. I'm going to bring this to a close. Greg, can't thank you enough. Guys, there's a reason that Greg is one of our trusted referrals here on the site. No doubt you've seen why. But of course, it's not only Greg. There's a whole range of professionals that are capable of answering your questions. The critical component is to know your own competence, as with everything. And when things get out of hand, to bring someone on board early and often, such that you are guiding your clients properly through what is a downward market and can be a raucous event for everyone involved. Greg, I want to thank you. I want to also mention that you're the first person to get 300 RSVPs, and you had 192 people at the height of this. So quite a few people tuned in, found this interesting. This will be posted. Yes, it will be posted online now, and I will append Greg's slides as well via a link. So thank you to everyone who came. Have a wonderful day. Let's keep being profitable while making sure that we are serving our clients legally and to the best of our efforts. My best, guys. Thank you, Greg.
Thank you.
Thanks, Greg. It was excellent.
Thank you, Greg, Mark, and Sandra.
Thank you, everybody. Thanks, Mark. Appreciate it.